Good, whenever this is. Good morning, good afternoon. This is a follow up to my update of yesterday about Alpine, GTI, Finra, etc., because it required an update. So, not legal advice. Like, subscribe, please share, show your animals, dogs. My Ridgebacks love my videos, even though I don't watch them. Um, anyway, appreciate you checking this out. So yesterday I did a update on the appeal and briefs that had been filed, and literally, I think so. This is all Pacific time. Let's say at 3 o'clock, I checked the site and looked at all the briefs that had been filed and made a video. After I released the video, I went back and there were three more briefs that had been filed, and then when I went back this morning, there were two more. So five more parties filed friends of the court briefs, which I'll address briefly in a second. But before we get into that, of course, I wanted to discuss a couple of other things. So, how does the ocean say hi? Of course, it waves. And why do birds fly south in the winter? Because it's obviously faster than walking. And what do you call a couple of chimpanzees who share an Amazon account? Of course, you call them prime mates. Of course. Anyway, so talking again now about the Alpine appeal. And again, just to refresh, this is the appeal of the district court. So the federal district court in DC denied Alpine's injunction, even though the appellate court reinstituted that. The appeal that is pending that I'm referring to is of the district court's denial of that injunction. So that's what this whole appeal is. And as I indicated, there are a bunch of parties who are friends of the court who are filing briefs. And even which is odd because we're only talking about an injunction, not something that's actually on the merits. So it's interesting that everybody has interest. And the reason why they all have interest, of course, or at least the ones that are currently filing, the 8 or 10 friends of the court as to FINRA, is because these are either similar organizations like the DTCC, for example, or they're self regulatory organizations like FINRA, or they're similar, as you will see, and they want to protect their status. They want to, of course, protect their money. They want to protect their power, and they all want to retain immunity at the same time. So, most of all these organizations want to keep the status quo. And none of us, okay, I'm speaking for everybody, there are some of us who don't want the status quo to remain because we don't believe the regulatory system is effective for retail. And we believe that substantial changes have to be made. We don't want the regulatory system to cease to exist. We just want it to be effective. So, um, I talked about one thing that I talked about before I get into the new 5 briefs that were filed, which I will be quick about because can summarize quickly, was I believe the SEC should really take over Alpine. Why should they take over Alpine? They didn't collect that. So Alpine was prescribed a penalty of $12 million for violating the Bank Secrecy Act. The Bank Secrecy Act is supposed to protect Americans in the country from terrorism and anti laundering. They violated that thousands of times. That fine and their misdeeds were confirmed at a court of appeal level in the federal court, and that's where it ended, the very end of 2020. Since that, as far as I know, the SEC and FINRA have not done anything to verify that Alpine is complying with the Bank Secrecy Act. So, if in fact they were laundering money or feeding money to terrorists prior to 2020, we don't know if they're doing that today. And I don't know if they were doing it. I just know that they violated the Bank Secrecy Act, and that's what that was designed to prevent. And I have no reason to believe that the SEC or FINRA is monitoring that. So they're, besides everything else, besides every nonsense and improper regulatory supervision that's been engaged in by the SEC and FINRA, they're also potentially leaving us susceptible to terrorism by not properly monitoring the banking and trading systems. And again, it's the SEC who filed the action against Alpine as to the Bank Secrecy Act, why they're not trying to collect their money and put them out of business, why they're not managing them to make sure they're not engaging in the same dangerous practices, I don't know. And it's something that we should all be concerned about, something we should bring to their attention. It's something we should bring to our congressional representatives, senators, press, etc. I think the SEC and FINRA are leaving us exposed and dangerously exposed. And it's not something a lot of people are talking about, but it came through specifically in Alpine. So that's why it's up there. So again, it's unusual to see this many amicus briefs, the friends of the court briefs. Um, it's interesting to think about what would happen based upon the outcome of the appeal. If so, this appeal in district court of the denial of the injunction uh, for for Alpine, and again that relates to the expedited proceeding that Finra took to get rid of Alpine in 2023, long after they already had gotten an order to expel in 2022. So it's that denial of, so Alpine went in, wanted an injunction to stop that. The district court denied it. So that's the real issue. And there's other cases that are on appeal, which is interesting. In that same district, there's a Kim case and there's a Lebensteel case. The Kim is actually on appeal already. And what's interesting about Kim, so Alpine, a lot of people must suspect that it may go up to the Supreme Court. That's why everybody's filing briefs. Kim is on appeal and might face the same uh, journey. And the reason why Kim and the other case I just mentioned, Lebenthal, which I think is behind these two cases, but if you have a case that goes up to the Supreme Court, you want a good plaintiff. You don't want a dirty sleazeball. Alpine is a dirty sleazeball. Just objectively speaking, if you look back at all my videos, objectively speaking, they're dirty sleazeball. They in Wikipedia, if you look under scumbags, that's their photo. So that's what they are. So if you take it up to Supreme Court, if this case eventually gets to the Supreme Court, the court may not want to rule in favor or even take a case involving a plaintiff like this. And that's why the other cases that might arise out of that particular circuit, being Kim, which is a case, and the Lebensteel case, in the same circuit, those plaintiffs might be cleaner, even though those are enforcement actions too. So we're not talking about potentially angelic parties, but they may be better than Alpine, who are perfectly scumbags. So, but we don't know yet. We don't know because we don't know how the court's going to rule. We don't know how the court's going to rule in Kim. And again, the difference between the case that I've mentioned before, Juraski, which is going up to the Supreme Court arguing end of November, that involves the power of the SEC. Alpine involves the power, Alpine, Kim, Lebensteel involve the power of FINRA. And if in fact the court finds that the SEC is operating improperly, it's likely that FINRA, who's one step removed, who's a private entity, who's not the government, would have bigger problems. And that's again why probably all these briefs are coming in from various parties trying to protect their interests. So I'm going to go briefly over the briefs that were filed since I gave my video yesterday. So literally an hour after, when I went back to the site, these had all been filed. Maybe they watched my video, they wanted to get on fast, but just kidding, of course. So the Department of Justice Civil Division filed a 69-page brief, and they again basically said that Finra is a private company supervised by the SEC, so they're not subject to the non-delegation treaty since they're properly supervised, and they're not part of the government, so they're not required to comply with the Constitution. Then we had that's my summary of their 69-page brief. Then we had a brief filed by the Public Investors Advocate Bar Association, and they again said that FINRA is private, they protect public investors, and there would be great harm to the public if FINRA was penalized and their ability to supervise and protect the public was restricted. They again said that there's a valid delegation of the duty because there is supervision by the SEC, and the appointments clause didn't apply because some statutory issue that really didn't make a lot of sense to me, to be quite honest. We also have, on top of that, those were the two quickies that I mentioned yesterday. Subsequent to that, we have three: the National Futures Association, the DTCC, and Benjamin P. Edwards. The National Futures Association is another exchange self regulatory body. The DTCC is like FINRA. And Benjamin P. Edwards was a law professor at the University of Nevada, Las Vegas. They all filed Friends of the Court briefs in support of FINRA, and basically arguing the three of them that FINRA is private, they're important, they help protect the public, we need them to regulate the industry, and that's basically it. That's the summary of those three briefs in way over the amount of time that they needed to spend. So they supported the two prior briefs that I had mentioned. So on top of that, today, when I looked, there were two more briefs filed in support of FINRA. This was filed by Box Box Exchange LLC, and it's a whole bunch of security exchanges of various sorts. And again, they support FINRA. They say self regulatory organizations are important. They do important work. They're private. They're privately funded, privately governed, which makes me wonder why they're immune. If that's the case, if they're perfectly private, why do they get governmental immunity? Why do they get the benefit of immunity that government gets? But anyway, Bach Exchange and a bunch of related exchange also filed the Friends of the Court brief, as I indicated, and they, in essence, say that FINRA is not a state actor, the self-regulatory system works, and so vote no uh, against the injunction. So support the district court's denial of the injunction. And then on top of that, we got another one that was filed by the Horse Racing Integrity and Safety Authority. And that's an organization that was established after there were a lot of horse deaths that occurred at various racetracks across the country. As a result, there was a private organization that was set up to monitor and devise safety standards. And even though it has nothing to do with securities, they believe because they're a government established self regulatory organization and they're based on the model of the SEC FINRA model, that therefore they believe that the self regulatory model and FINRA and the fact that they're a state actor should be upheld. They shouldn't be restricted. And again, if they are restricted, there will be great harm caused to all the other self regulatory organizations and other bodies that regulate matters such as these for the public. So, again, another set of organizations that are trying to protect, in essence, their own eggs. Because if they believe that if FINRA goes down, then perhaps all these self-regulatory organizations have to take another look at themselves and how they exist and how they govern. So, as I indicated, since yesterday's video, there were another 5, all in support of Finra. And just cutting to the chase, there may be additional ones. We have a reply one, as I mentioned. But it'll be interesting to see how it all plays out. And it'll be interesting to see if the court takes a narrow reading. As I indicated yesterday, the court could rule on all these constitutional issues, or they could rule narrowly, as they're supposed to, and just focus on the fact of the injunction and that Alpine were scumbags. And since one of the requirements in an equitable argument that was made by Alpine for the injunction, one of the requirements is that the party who's seeking relief has to be acting in good faith, and that the balancing of equities favors them over the public. And I think you could just look at that one factor and kick Alpine out of the box. As to this injunction, so the ruling of the district court would be upheld. If Alpine wanted to appeal that to the Supreme Court, I don't think it would be accepted. If Finra loses in the district court and the injunction should have been granted, then I would expect Finra to appeal directly to the Supreme Court, because that would be at issue now. And because the Supreme Court accepted the Jureski case, it's possible, and maybe more than possible, that the Supreme Court would accept the Alpine case if there was a finding that what Finra was doing was not constitutionally permissible. But we're putting the cart ahead of the horse at this point in time. So again, I'll keep you apprised of any additional briefs that were filed. So these are the briefs that were filed as of November 3rd at the end of the day. And we'll see. I'm sure there's additional briefs that are coming, and there may be other twists and turns. Hope that this added some additional clarity. Have a great day. Have a great weekend. See you later. And now I have to end the